Just to refresh your memory, there are three things that the claimant has to prove in order to succeed with a claim for negligence. And that is what we call the tortfeasor. So the person who commits the tort or allegedly committed the tort is called the tortfeasor. So for negligence, the three things that the claimant needs to prove is, number one, starting with the duty of care. So the claimant has to prove to the court that the defendant owed the claimant a duty of care. You'll remember last week we looked at what specifically does that mean, and we've looked at cases where it was very clearly set out that this duty of care must be owed to the specific claimant. It's not enough to say that there's a general duty of care. When we looked at duty of care in negligence, we looked at how do you actually go about proving that to the court. So after that, once you've convinced the court that there was a duty of care owed to you as the claimant, the second element is the claimant has to show that the defendant breached the duty of care towards him. And finally, that breach of duty caused the damage suffered by the claimant. We call this causation. Now, this third element implies that you also have to have suffered damages. So this is not a tort that is actionable per se. It's not a tort where you can go to the court without having suffered damages in the form of either personal injury or damage to property. For this tort, you have to prove that you've suffered the kind of damages that you can claim for in negligence, and you also have to draw a link between the breach of duty of care and the damages that you've suffered. And that is causation. So we've looked at duty of care. We've looked at how do you prove that there was a duty of care. And today we're going to go on to the second element, and that is proving to the court that, well, there was a duty of care, but now you're going to prove to the court that that duty of care was in fact breached by the defendant. As always, with all civil claims, the burden of proof, so in other words, the question of who needs to prove that there was a breach of duty, it rests on the claimant. And this is the same with, it's a truism, it's a rule of our law that he who avers or he who alleges has to prove. So if you go to court and you allege that somebody breached a contract, if you allege somebody caused an accident, you, the person who alleged that, have to go and prove it to the court. And once he's proven the case, then it's up to the defendant to see whether there's any possible defense. But the main burden always rests on the person who alleges. So that is the claimant in a civil case. In a criminal case, the burden of proof lies on the state. So it's the state who alleges that an accused person committed a crime. And it's up to the state, it's up to the Crown to prove that the accused committed the crime. So it's not up to the accused to show that he's innocent. It's up to the Crown to show that the accused was in actual fact guilty. So coming back to tort, the claimant has the burden of proof for all of the elements of the specific tort. The burden of proof lies on the claimant for negligence to prove there's a duty of care, there's a breach of duty, and causation of damage. Don't get confused. The reason why I step back to what you by now know as a very basic rule of our law, namely the burden of proof. Why did I go back to that? I went back to that because I want you to be very clear and not to confuse burden of proof with the standard of proof. When we talk about burden of proof, that means we're now talking about who has to prove, on whom does the burden lie. But if we talk about the standard of proof, we talk about what does this person need to prove. So now we're talking about the substance of the claim rather than the person. Okay, so the standard of proof, let me just very quickly ask you, what is the standard of proof in criminal cases and what is the standard of proof in civil cases?
So in criminal cases, the standard of proof is beyond reasonable doubt. And in civil cases like tort, it would be on the balance of probabilities.
Okay, if you think about it in terms of statistics or in terms of percentages, when you balance something, things are sort of equal, okay? And if you tip the balance, you can tip the balance just a little bit. So 50-50 is completely balanced. If you've got 49-51, that tips the balance in favor of somebody. So on a balance of probabilities means that all that you need to do is you need to go beyond that 50%. So you need to convince the court that there's more than a 50% probability that the person committed the tort, and then you will win your case. You just need to tilt that balance. But beyond reasonable doubt means that you face a much more challenging battle. You have to convince the court beyond any reasonable doubt. There is a 99.99999% probability that the accused committed the crime. So you see, convincing, just tilting the balance in favor of your client is easier than it is to convince the court that there's no doubt, almost no doubt, this person committed the crime. So it's the difference between 51% and 99.9%. And why is this? Why is it more difficult for a criminal to, in a criminal case, to prove your case as the Crown against an accused than it is in a civil matter? It's because the results of a criminal case are much more serious. If you're found guilty of a crime, you face time in jail. You've got a criminal record, that's going to have an impact on your whole life. So coming back to the breach of duty, the claimant now has to show, the next step that he has to do is he has to prove that in this specific instance, on a balance of probabilities, that the defendant fell below the appropriate standard of care. So the next question then is, so what is the appropriate standard of care? How do we figure that one out? That is the way in which we judge whether or not a person fell below the standard that would be expected. In negligence cases, we use a test called the reasonable man test, commonly referred to as the reasonable man test. And that reasonable man nomenclature, so in other words, the term the reasonable man, was first coined in the case of Hall versus Brooklands Auto Racing Club. You don't need to know the facts of this case, but there was a description given in that case that sort of tries to tell us who is this fictional reasonable man, because the reasonable man is not a real person. It's a legal fiction, a legal test by means of which we decide whether or not a person's action was on the appropriate standard. So the test that we use is the court will ask, under these circumstances, what would the reasonable man have done? If the defendant acted to that same standard, or even if he acted above that standard, he will not be held liable. Then we will say he's done everything we would have expected a reasonable person to do, and that means that he did not breach his duty of care. However, if the defendant fell below the standard of what we would expect the reasonable person to do, then we've proven to the court that the defendant fell below the standard of care and the defendant therefore breached his duty of care. The question then is, what are the characteristics of this reasonable man? This creature of fiction, this mythical person, what is he or she like? In 1933, you can go and have a look at that case. It's quite interesting to see what the notions in 1933 was of what is your average ordinary person. It's a person that's not a genius, but also not an idiot. And they actually use these terms in the case. So it's a person of reasonable intelligence, your average person. They refer to this person in Hall as the man on the Clapham omnibus. So it's the man on the Clapham bus who works in London, for example, goes home, mows the lawn, etc. There's a whole list of things that they list there, which is quite interesting in a little glimpse into 1930s. Updated quite recently, or more recently, in 1999, they said, well, the reasonable man today, instead of being the typical man on the Clapham omnibus, we can think about the typical person on the London Underground. However you explain or try to picture the reasonable man. It's a person of average intelligence, not too clever, not too foolish, a person that you would expect the average person to be. This reasonable man test is an objective test, and it is actually a legal test. So it's like it's a standard, and this standard is set. It's not mutable. It doesn't change according to who we're dealing with in general. Okay, so in general, the same standard is applicable. And that is what we mean by an objective test. An objective test means it's something outside against which we are all judged. Subjective tests would be specific to the person that we are judging. So then you take into account the specific skills of the person, the specific shortcomings, what they were thinking, etc. Another way of thinking about it is when you think about fault, and remember fault refers to intention, for example. If you have to figure out whether a person had the intention to do something, that is clearly a subjective test, because you have to figure out what was going on in that person's mind or heart. So that's person specific. Objective test is something that is outside of the specific person against which everybody is judged the same. Now, this was explained in quite a bit of detail in the case of Nettleship versus Weston, or it illustrates the point very well. In the case of Nettleship versus Weston, a learner driver caused an accident, and then the argument by the learner driver was that, well, yes, one road user does owe a duty of care towards another road user, but when we think about falling below the standard of care, the argument went that if I'm a learner user, I can't be held against the same standard as other road users. And the court said, no, the objective test is the same for everybody, regardless of your circumstances. So whether you've been driving for 50 years or whether this is your first time on the road as a learner driver, all of us, once we drive on the roads, we are kept to the same standard. And that standard is the reasonable man test. Now, the reasonable man test it's a legal fiction. So in other words, it's a rule that is made up and it is used in the law, but it is used as both a matter of law and also as a matter of fact. So when I say a matter of law, then what I mean is in the courts will examine the legal rules and they will judge something against the legal rules. Whereas a matter of fact is where you have to look at the facts of the specific case. So the reasonable person test illustrates this. The reasonable man test is an objective test, meaning that it's a test set by the law and it's the same for everybody. Now this test then becomes a matter of fact because you then take into account the specific facts of your case and you judge them against the matter of law. So the facts judged against the legal rule. So the facts of the defendant's conduct, you take the reasonable man test and you say, in these circumstances, what would the reasonable man have done? And then you compare the defendant's conduct against what we would have expected of the reasonable person. If the defendant's conduct falls below what we would have expected of the reasonable person, then we have breach of duty of care. If it's the same as what we would have expected, or if it's even better than what we would have expected, then we don't have breach of duty of care. And what does that mean? That means that your claim in negligence will not succeed. Right, now, having told you that the reasonable man test is an objective test, meaning that it's the same regardless of whether you have lots of experience, whether you've got little experience, doesn't matter. We now have to go and look at the exceptions to that rule. Lewis Hamilton causes an accident. He will be held to the same standard as when you are causing an accident. So we're not going to hold Lewis Hamilton to a higher standard on the roads. We're going to use the reasonable driver as the standard. No allowances made for any special characteristics on the part of the defendant. That's the general rule, the reasonable man. But as with any law rule, you know already that we usually have a general rule and then we've got exceptions to that. And the breach of duty of care is exactly the same. So the reasonable man test has its exceptions. And this is where we look at special standards of care. So if we've got a professional defendant and the case relates to the exercise of that profession. Please take note, we've got a professional defendant and the case relates to the exercise of that profession. It's only if it's with relation to the specific profession that we have a special standard of care. So it's not, so this would be, for example, where we've got a brain surgeon and he did brain surgery and the patient then is injured and the patient now sues him for negligence. So a brain surgeon doing brain surgery and being negligent whilst doing the brain surgery. Now the special standard of care for that situation kicks in. As opposed to that brain surgeon getting into his car and driving home and causing an accident. Under those circumstances, even though he is a professional, the special standard of care would not be applicable to him because he's not engaged in his profession. Let's make it a little bit more concrete. I told you about Lewis Hamilton. So let's say Lewis Hamilton is on the M25 and he's driving home. He was out in London and he's now on the M25 driving home to wherever he lives. So let's say he's on his way from London to Stevenage, he's crossing the M25 and he's involved in an accident. And the person who is injured now sues Lewis Hamilton. Will Lewis Hamilton be held to a higher standard of care because he's a professional? No, because he's not engaged in his profession. We have the reasonable man test, which is an objective test for everybody judged against the same standard. There are exceptions to that. The first exception is where we've got a professional defendant and the case relates to the exercise of that defendant's profession. The same thing goes for a specifically skilled defendant. So let's say, for example, an electrician engaged in his work as an electrician, and we now have a complaint that he was negligent while he was doing his electrician job. Now, with the professional defendant and the skilled defendant, the standard of care that we will use there will be a standard appropriate to that profession. So let's say we're talking about a brain surgeon, it will be the reasonable brain surgeon. If we're talking about a skilled defendant, such as an electrician, it will be the reasonable electrician. So those will be sort of a higher standard than the reasonable person, because the reasonable person will not necessarily be a person with skills or with a profession. With children, we look at the reasonable child of the same peer group. So this would mostly mean the same sort of age group as the child. And then we've also got specific rules for specific activities. So you can imagine for some activities, there's a higher amount of risk, whereas other activities have less risk associated with them. And then we've got emergencies. So in emergencies, we are not going to keep people to the same standard of care. So we will assume that if you're acting in an emergency, you will probably not be as careful in your conduct as you would under normal circumstances. Let's look at these then in a little bit more detail. So firstly, we'll start with the professional or the skilled defendant. And as I've already said, the test would be the reasonable peer group. So heart surgery, the defendant is a heart surgeon. He will be judged or she will be judged against the reasonable heart surgeon. Having mentioned brain surgeons and heart surgeons, this brings me now to more specifically medical negligence and medical negligence cases. With regards to medical negligence cases, it's a little bit difficult, and we've already seen how even with the first element of negligence, the element of duty of care, The courts are very reluctant to, when we're talking about public authorities, and this sometimes includes hospitals and NHS departments and so on, the courts are very reluctant to even recognize that there is a specific duty of care owed, because the courts don't want to fetter the discretion. The courts don't want to put the fear of the law onto people that we want them to act fearlessly. We want them to be able to make split-second decisions as necessary without worrying the whole time that they're going to end up in court being sued. But as we've already seen also, that doesn't mean that they cannot be held liable in negligence. They can. If you've shown that, yes, there's a duty of care, then the next step is to show that they fell below the reasonable standard. And with medical cases, that brings us to another problem, because the reasonable person in medical cases, sometimes this is very difficult to prove, because especially when we're talking about cutting edge procedures, especially when we're talking about new medicines, new medical procedures, etc. At this cutting edge, sometimes even the medical professionals cannot agree that this is the correct way to do things versus another option that you could follow. So the courts then have a quandary. If they're confronted with two sets of expert evidence, where one set of experts agree with the claimant and another expert agrees with the defendant. And that is what happened in the case of Bolam versus the Free and Hospital Management Committee in 1957 case. In this case, the claimant was subjected to electroconvulsive therapy, more commonly known as electric shock therapy, which was used and still continues to be used for a variety of mental health issues, including, for example, very severe cases of clinical depression. Now, the issue here with Mr. Bolam was that he was given the electric shock therapy and he wasn't given any muscle relaxants beforehand, and he was also not restrained. So he wasn't strapped down. And when he was given the electric shock therapy, he suffered fractures. So some of his bones, I won't go into too much detail, it's quite gruesome, but he suffered severe injury. And he then sued the hospital for negligence. So at the trial, he led evidence by medical experts that who said that if they were given electroshock therapy, they would give muscle relaxants and they would also restrain the patient. But the defendant brought medical experts who said that no, this is exactly the wrong thing to do, because if you give muscle relaxants and then electric shock therapy, the heart could stop. And if you restrain somebody, even worse fractures could result. So what was the court to do? Well, the court said, in this instance, you have to give the benefit of the doubt to the defendant. So you have to give the benefit of the doubt to the defendant. If the defendant can bring evidence from any reasonable peer that they would have done the same, then the court has to accept that. So what this means is that in medical negligence cases, if the medical defendant can show that another respectable doctor would do the same as he or she did, then there wouldn't be any conclusion by the court that they fell below the standard of care. Then, a bit later on, you'll see 1997, from the case of Bolam until then, there's been a lot of uneasiness with the Bolam test, as it is known. And by then, things have changed a bit. By the time that the case of Belitho came to the courts have sort of come to the conclusion that it's too easy for medical professionals to dodge responsibility for negligence by bringing another medical professional as proof that they would have done the same. So in the Belitho case, the court said, well, we're still going to give the benefit to the defendant, as we should, if the defendant can show that there's a reasonable peer group that would have done the same. But that doesn't mean that we're not going to exercise our discretion by judging the two expert evidence. So meaning that the mere fact that the defendant could bring another body of professionals that would have done the same would not be enough. This still needs to be judged against the opposing body of evidence given by the claimant. So the court still has to weigh up these two sets of expert evidence. So very briefly, the facts in the case of Blytho. In Blytho, this was about a little boy, a toddler, who was taken to hospital, and he had a chest infection, and they put him under observation, and he was doing well until he wasn't doing very well anymore. And in the end, the little boy died. And then his parents sued the hospital in negligence, and the parents brought medical experts who said that they would have intubated the baby, the boy. Intubation is where they quite literally put a tube into your base of your throat if your throat is too swollen up to be able to breathe normally, so that air can come in, get into your lungs. The parents brought medical evidence, expert evidence, that who said that they would have intubated the little boy. But the hospital, on the other hand, brought medical evidence that backed up what their doctor on duty did, which was not to intubate the little boy. And this set of expert evidence said that, if you think about a boy of that age, intubation is a very scary procedure, even for an adult. And if you can think about a little boy who doesn't understand what's happening, getting him to submit to this sort of thing could have been the very worst thing that they could have done. So the court had these two opposing sets of expert evidence, and the court agreed with the hospital. So the difference between Bolam and Blytho is the Bolam test is still applicable. So in other words, if the defendant can bring experts that say that they would have done the same thing, then the court will follow that, unless they are more convinced by the expert evidence brought by the claimant. This is what was decided in Blytho. Moving on from the skilled defendant, we now go on to the other side of the spectrum. So if we are talking about a defendant who's not very skilled, usually we don't make any allowances. So bringing your attention back to the case of Nettleship versus Weston, where it was decided that we don't make allowances for learner drivers. If you're on the road, you owe a duty of care towards other road users the same as the reasonable road user. So in the majority of cases, we don't make any allowances. That is what an objective standard means. Everybody kept to the same standard. The exception is when we're dealing with children, because here we do make allowances for the fact that children are less skilled, they've got less ability to make reasonable decisions than adults do. So with children, we judge them against their reasonable peer, and we also take into account that sometimes, you've got a very old child and you've got a very young child, regardless of what their physical age in years are. We also have special standards of care when we deal with sporting events. So with sporting events, we've got a lower standard of care. We recognize that when you engage in a sport, you're not going to be as careful as you are going about your other daily activities. So with sporting events, you have to be more negligent to be held liable than if you're just, for example, walking down the road. The courts have called this a reckless disregard to safety. So it's more than just being ordinarily negligent. It's very negligent, a reckless disregard to safety. Let's look at a few of these. In the case of Mullen versus Richards, this gives us an example of how do the courts apply the test of a reasonable peer in cases relating to children. In Mullen versus Richards, two 15-year-old girls were playing swords or playing at fencing with their rulers, and one got injured. The injured party then sued the defendant and said that this was negligent, but the court said, if you think about the average 15-year-old, the average 15-year-old doesn't act, we can't expect the average 15-year-old to act the same as an adult person. And 15-year-olds are a little bit more reckless than we would expect adults to be. And engaging in this, you wouldn't expect two 30-year-old people to play fight with rulers, but 15-year-olds, yes. So yeah, the defendant, according to the court, did not fall below the standard that we would expect of your average 15-year-old. So there was no breach of the duty of care and no negligence proven. On the other hand, another case that shows where the court did feel that a child fell below the standard of what we would expect a reasonable peer is the case of Keown versus the Coventry Healthcare. This was a case of an 11-year-old being naughty and climbing on a fire escape in a hospital and then getting injured. And the question was whether or not the hospital should have expected or should have done more to try and prevent this from happening. The court said in this instance, the 11-year-old could read. He saw that there was, signs saying no admittance, and he knew what he was doing was wrong. And the court said an 11-year-old knew under these circumstances that what he was doing was wrong. There are other cases as well. You'll see quite a number of cases. So take your pick. Remember that with, let's say that you've got an exam question or so on this, whenever you give a statement of fact or a statement of law, you have to give proof. So you can use a number of cases to illustrate your point, but you always have to use at least one case if you make a statement of law in tort. With regards to sporting events, with sporting events, we've got a lower standard of care because many sports are inherently risky. The chances of being injured in a football game are much higher than being injured if you walk on the pavement outside of your home, for example. We have a correspondingly lower standard of care for sporting events. And the idea here is that you willingly engage in an activity where you know that there is a risk of injury. So, for example, the case of Wooldridge versus Sumner, this was a case that was taking pictures at a horse event and was injured. And the court said, well, going there, positioning yourself where you are to take the pictures, you know that there's a risk. And the person causing the injury wasn't falling below the standard that would have been expected of them. So from this case, we get the additional rule that in sporting events, you can hold the person who injured you while you were engaged in a sporting event, either as a participant or as a spectator. You can hold the person liable in negligence, but you will have to understand that the defendant is given more leeway. So instead of being held to this standard of care, will be held to a lowered standard of care. So the defendant will only be seen as having fallen below the standard of care if the defendant had a reckless disregard to your safety. So what does that mean? What does a reckless disregard to your safety mean? It usually means that the defendant wasn't playing within the rules. If the defendant was playing within the rules of the game and you unfortunately got injured, then they won't be held liable. But if they were breaking the rules of the game and you got injured, then the court will infer that they had a reckless disregard to the safety. So, for example, if there was a foul tackle in a rugby match or in a football match and you got injured because of that foul, then you would be able to sue the person in negligence who caused your injury. Okay, so remember, with the standard of care, we use the reasonable man test. That's the gold standard. We judge what the defendant did against what would we have expected the reasonable man to have done. This reasonable man is a fictional person, doesn't really exist, but the average intelligent person on the street. If we're dealing with professionals engaged in their profession, then the reasonable man then is the reasonable professional. If we're dealing with children, the reasonable man becomes the reasonable child of that peer group. But let's just get back to the reasonable man. The court imagined this person against whom the defendant is going to be judged. But there are other things that the court will also take into account to form a picture of what would the reasonable man have done. So these factors that we're going to look at now, you can think of these factors as helping the court to set the standard. Okay, so helping the court to put the reasonable man into a specific context. So the courts will look at How foreseeable is the harm? So remember the case of Roe versus Minister of Health? This was the case where at that stage, they didn't know that glass is permeable. They thought that if you put something in glass, nothing can get through the glass. And we now know that it's not true. There are microscopic little openings in the glass or cracks in the glass through which things such as formaldehyde can actually get into the vial. But before the unfortunate case of Roe, we didn't know that. So before then, the standard of care was different. So we look at how foreseeable was it, looking at the specific facts of the case. We also look at the magnitude of risk. The court will look at what are the chances of this happening. Is it a 1 in a million chance, or is it a 1 in 10 chance? And here it would be as easy as looking at how often does this happen. There's, for example, the case of Bolton versus Stone, in terms of which a ball was hit out of a cricket field and it injured a person walking on the street. And it was very, very rare that this happened. So the court said in this instance, they didn't fall below the standard of care. But let's say that this is something that happens very often. Let's say the cricket pitch is in the middle of a little village and it happens almost on a weekly basis that somebody gets hit by a cricket ball. Then the magnitude of the risk is higher, then the chances are higher. So the court would then say, if you know that it very often happens that you hit a ball out of the cricket field, then you'd need to take more precautions. Then the reasonable person would be expected to be more cautious. The courts also look at the social utility of the activity. This is where the courts don't want to necessarily stop something because there is a risk that something somewhere could happen. So they balance the utility of the activity or the benefit to the society versus the chances that things can go wrong and somebody could get injured. So if there's a lot of benefits to society, then the courts will be very hesitant in saying that, yes, you need to take more precautions. You don't want to kill all of the joy of, all of the benefit to the society. And this was what happened in the case of Tomlinson versus the Congleton Borough Council. In this instance, there was a lake in the borough of Congleton, and this lake was used by families. There's a little beach there, and they took their children there for picnics and for paddling in the shallow water, etc. But it was also recognized that, this is a place where, with any body of water, you can, for example, drown if you don't know what you're doing. There's also, it's shallow and rocky, so not suitable for people diving in. So there were signs put up around the lake saying that it's not suitable for swimming and for diving, etc. But lo and behold, what happened? Mr. Tomlinson disregarded that, dived, and got very seriously injured. He then sued the Congleton Borough Council in negligence. And you'd be amazed to hear that even up to the appellate court, the courts agreed with him that the Borough Council they had a duty of care towards the people using the area, and the court said that they fell below the standard of what would have been expected. So the question then is, what would have been expected? And it looked as if the only option for the Congleton Borough Council would have been to actually stop people using the lake altogether, even going so far maybe as to fill in the lake so that people can't use it. So when this got to the Supreme Court, the court said, well, no, you don't want to do that. The vast majority of people using this lake used it responsibly. And you have to take into account that you have individual responsibility for your own safety as well. So if the defendant put up notices saying that use at your own risk, or this is not suitable for swimming or diving, that would be what we would expect a reasonable defendant to do under these circumstances. So there, the court weighed up the benefit to the society of this lake and the standard of care that would then be expected of the person in charge or the institution in charge of the lake. The court also looks at the practical, how practical is it to take precautions. For example, in the case of Latimer versus AEC, the question was a wet factory floor. How practical would it be to take precautions, because wet factory floor can be very dangerous, and it's quite easy. You just put up a notice: wet floor, take care, or you mop up the wetness. So versus precautions that are going to be so expensive that it will put the entire thing out of business. The court also looks at what is the common practice. So in an industry, what are the safety standards in that industry? That will give us an indication of what the standard of care is in a specific context. Now remember, at the start of this lecture, we looked at the burden of proof. It's on he who avers has to prove, but we also looked at the standard of care, or the standard of proof rather, and we compared the standard of proof in criminal cases versus the standard of care in civil cases. The standard of proof in a criminal cases is beyond reasonable doubt, versus in a civil case, it's on a balance of probabilities. That means that in a criminal case, it's much more difficult to prove that the accused did something. You're also sure that in a criminal case, if a person is found guilty, it's almost 100% sure that he is actually guilty, because it's so difficult, beyond reasonable doubt. It's a difficult burden of proof. Now, just keep that in mind, because that brings us to a shortcut, which I'll talk about just now, in proving breach of duty of care. Now, the first shortcut is the legal rule that says res ipsa loquitur, or the thing speaks for itself. Now, in some instances, something is so obvious that you're not going to waste the court's time by trying to prove it, such as the sun rises in the east and it sets in the west. You don't need to go and bring expert evidence to the court to prove that, because it's obvious. You don't have to prove that a wheel is round, etc. We are going to look at res ipsa loquitur again. But the other thing that you need to know, which sometimes helps you in proving that there was breach of duty of care, is Section 11 of the Civil Evidence Act 1968. And this brings us to that standard of proof thing that we were talking about, beyond reasonable doubt versus on a balance of probabilities. Now, Section 11 of the Civil Evidence Act says that if you've got a matter that was also the subject of a criminal case, which you very often do get in tort, especially with personal injury cases. Think, for example, about a person who was injured in a motor vehicle accident, and this was because the person who caused the accident was driving under the influence of alcohol, for example. Now, that defendant could be held liable in tort for the injury that he caused, but that person could also be found guilty in a criminal case for driving under the influence, if that is the case. So in other words, if your case was also, or the defendant in your case for the same facts was found guilty in a criminal case, then that helps you in your civil case. Because the fact that he was found guilty in a criminal case, you can take that to the court as proof that he fell below the standard of care in your civil case. And that makes your job easier, because it means that you don't have to bring evidence and call witnesses, etc., because that has all been done for you already in the criminal court. Now, why can you do this? You can do this because in the criminal court, it would have been done beyond reasonable doubt. So it's without any doubt that the defendant did it. And you can take that to the civil court, and the court will take it as proven. It doesn't work the other way around. So if you're the Crown prosecutor, you cannot take the fact that the accused was found to be liable in a civil case as proof that he is criminally liable. Why not? Because of that difference in the standard of proof. Beyond reasonable doubt means that it's more than 50%. So that is why you can take the criminal case to the civil case and take that as proof for your civil case, because 99.9% is already more than 51%, but not the other way around. And that is, for example, the reason why, do you remember the O.J. Simpson case? So O.J. Simpson he was found not guilty in a criminal case of murdering his wife because it couldn't be proven beyond reasonable doubt. There was still doubt about it. But he was successfully sued in a civil trial by the family of his wife for the unlawful killing of the wife. Why? Because they could convince the court just that little bit more than 50% that he was actually responsible for her death. Right, now that brings us to the end of this lecture. Where are we now? We've looked at duty of care, we've looked at breach of duty of care, and next week we're going to start looking at causation.